What happened is she was in the back seat of the car with her newly born daughter and her mother. Her husband was in the right front seat and his son was driving. The son asked his dad to take over because of the nature of the road. He put it in park, and the husband and the son get out to switch sides. As they get out, the vehicle starts rolling, and it rolls off the edge of this roadway cliff. Her door opens, she falls out, and is crushed by the car.
All right, everybody, welcome to another great episode of Cases Gone Wild, and we have a great guest, and we have the craziest, wildest case stories for you today. I can't wait for you to meet our guest today. He's a national trial lawyer, but he's also based here in Michigan, and I would describe him with one word: fearless. And that's a word that I don't throw around lightly. But Bob Tyler is here today, which I understand it's your first podcast. Thanks for coming on the show, Bob. Thanks for being here.
Thank you.
He is a fearless guy. And we're going to talk about some of the crazy things and the crazy cases that he's done. Remember, if you like our show, please go give us a thumbs up. Please share it with your friends. You can watch us on video on YouTube and check us out on our Instagram, Marko Law, or Jon Marko, JONMARKO on Instagram. And you can share this with all your friends. Bob, thanks for being on the show, man.
Thank you for
inviting me. You are what I call an OG. Do you know what an OG is?
I have some definitions, but I'm not sure they're yours.
It's an original gangster.
Oh, okay.
Okay.
All right.
You are known as an OG. It's original gangster. You've been practicing for 35 years. You've taken on some really big cases. You've taken on, I use the word fearless. I sincerely mean that. And as we were getting ready for the show, I said you are the most fearless attorney I know. You've taken very difficult cases. You've taken very complicated cases. You've taken positions against some individuals who have powerful interests, and you don't seem to care very much. You stand up for what's right. I highly respect you.
Thank you.
And I wish more lawyers had your gumption and cojones, they say, when it comes to these things. So tell us a little bit about your practice. You do a lot of products liability, which is pretty dried up in Michigan, but you keep it alive, and you do med mal. You do a lot of complicated litigation. You're not just like a car accident guy.
Right. Usually, most of my cases come from referrals from other attorneys or from previous clients. So some of the more straightforward, like a auto negligence case, the underlying lawyer will have already taken care of that. So I do primarily product liability, medical malpractice, and some legal malpractice. And that has been the heart and soul of my practice ever since I was a first-year lawyer. And
you've gotten some great results over the years. Those are all what I would call high difficulty practice areas, right?
They are.
Slip and falls, you get hit by a car. Those are usually generally a little easier difficulty, but generally legal malpractice, you're going up against good lawyers. Products, you're going up against good lawyers from like big corporations like Ford Motor Company, things of that nature.
Right.
So, you're a really good trial lawyer, and you try cases.
I do. I've always thought that if you're going to be a litigator or classify yourself as a litigator, you need to try cases, because there are, unfortunately, people who say they're trial lawyers and they never really step in the courtroom for a trial.
Yeah, and for our listeners who aren't lawyers, it is like when I was a kid, I thought, all lawyers do what you see on TV, like Law and Order and Matlock and stuff. In Michigan especially, our trial lawyer bar, lawyers who actually go into a courtroom in front of a jury, is extremely light, I think.
When you put it up against the number of lawyers, it's a very small percentage. Even in the field of personal injury litigation. There are a lot of lawyers who do not try cases. And in my opinion, it increases the value for your clients if you're willing to try cases, because the defense attorneys and the defendants know who will try a case and who will not try a case.
Exactly. I encourage anybody who's looking for a lawyer, when you meet with that lawyer, he's going to tell you all kinds of stuff about how great he is or how much, ask him or her, when is the last time that you tried a case and how many cases have you tried to a jury verdict in your career? I think the answers might be surprising for a lot of people.
Absolutely. It will be.
And I agree with you. I was talking with a great mediator who I won't name, but he told me that the insurance companies, some of them actually have data lists of when was the last time the lawyer tried a case. He said he was in a mediation and the lawyer for the injured person said, I'm going to try this case. I'm going to get a jury verdict and try this case. He conveyed that to the insurance company, and the insurance adjuster said, no, he's not. And he said, what do you mean? She goes, he hasn't tried a case in 18 years. Here's the last case he tried. They know this stuff, and it affects the value on the case.
I honestly did not know that. It doesn't surprise me because obviously they keep stats on a lot of things. But, generally you have a reputation. You either try cases or you don't try cases. And but they've taken it to a higher level, I guess.
Yeah. Bob, I want to talk to you about, I just read Michigan Lawyers Weekly, which is a publication for lawyers that comes out, and they have some of the biggest cases. I just read your name on a case out of Washington State.
Yes.
For some ungodly number. It was like over $25 million. Can you tell us about this crazy case that you just did out in Washington?
The underlying facts are an unfortunate situation where an iron worker was working in Michigan, in Wayne County, actually, and he had a self-retracting lanyard. People probably recognize it as a lifeline, so that if you fall, it's supposed to sense the fall and lock up and arrest your fall, so you don't end up, hitting the ground or other structures.
Like a cord that is attached to something?
Well, it's a cord, but then it's attached to a mechanism that has devices inside that will lock up.
Like a seatbelt when you get in an accident.
Right.
Locks, right? Okay.
Same concept. And in this situation, he fell at the job site.
Was he working up high or something?
He wasn't working up high. He was working at ground level in a steel mill, but he was working on part of it that had a large drop down to the,
like
I'm not going to say
stuff.
basement, but yeah, basement would be a good way to explain it. He hooked up, tested his lifeline, which is called a jerk test to make sure it locks up. It passed that. And then he stepped over the rail and was getting ready to do his work, and then he fell, and it was all captured on video.
Oh my God!
From the plant, and he fell. The lanyard did not lock up, and he was impaled on a structure down below. He was alive for a while. Realized how seriously injured he was, which made everything worse. So
did he pass away?
He passed away. He was in his 40s, had a son, and a family. Obviously, as an iron worker, was making a good wage.
Right.
So the lanyard was tested afterwards because it belonged to his employer, who was a subcontractor to the plant. And it failed in those tests. They then tested a number of the other similar lanyards, all of which were relatively new. They were not had not been around for a long time. A number of those failed. So we then made a claim. The manufacturer was in a country outside of the U.S. The distributor was in the state of Washington, but had distributed it nationally through local distributors to the ironwork company. We found that inside the lanyard, the way it had been designed, It was designed with opposing metals, so a galvanic corrosion was set up, so the metals were interacting with each other.
They were like grinding each other inside.
No, it was like a metal reaction. You put two opposing metals, they will start to react, and they will start to change, or they'll start to corrode. So when they corrode, it's like everything else that we know, that you get something that's rusty, it's not gonna
work.
Not gonna work.
That's crazy. I mean, this is not the type. This isn't like a toaster that just stops working. This is a lifeline, people's lives.
Its one and only job was to stop the fall. So we sued the distributor and the manufacturer in Wayne County. The manufacturer came in and filed a motion to have it dismissed, saying there's no jurisdiction. We do not do business in Michigan.
Where was the manufacturer from?
India.
Okay.
The trial court granted that motion. Obviously, I opposed it. They granted it. I filed an appeal on it, and it was up in the appellate court. The time limit for filing a lawsuit had not expired, so we knew for sure that we had jurisdiction over the Indian company in Washington. So we filed.
Why would you have jurisdiction over this Indian manufacturer in Washington but not Michigan?
Well, they had entered into a contract with the Washington-based company to make and distribute these lifelines. So we knew they could not take the position that they did not do business in Washington.
Right.
So, not knowing for sure what the Court of Appeals would do, obviously knowing what we thought they should do, we filed in Washington. The manufacturer then came to me and said, we'll agree to jurisdiction in Michigan. And at that point in time, we had obviously become aware of all the Washington laws, which they do not have damage caps, very liberal courts and jurors. So we declined their offer to litigate the case in Michigan.
That's a lesson to defense attorneys. Be careful what you wish for. I always tell my lawyers, think about how this is going to go down the road. So, sometimes you ask for something, you get it, and then it ends up hurting you,
Right. Well, in the time frame that I practice law, I've tutored a number of younger lawyers, and part of what I've always said to them is, whether you're on the plaintiff side or the defense side, you need to make a game plan of, this is what I need, this is what I want to do, and think it through and make sure that you have a good game plan, and then try to execute the game plan. So in this situation, I think, I don't know if it was the lawyers or if it was the company, but somebody decided, we're going to get this dismissed in Michigan.
And they probably didn't think two steps ahead, because it's like 3D chess. I consider law a lot of times like 3D chess. There's so many moves that can be made, and you got to think ahead. And I mean, it's very strategic to be a high level if you want to do high level. Right.
So when we litigated in Washington, we went through all of the normal what's called discovery, exchange of information, testimony, et cetera, and then we were scheduled for trial. And I had a co-counsel from Texas. I had local counsel in Washington, and we were geared up and ready to go to trial. So went out to Seattle, and then we had to wait until the judge was available.
So how does that work? I've heard about this like in LA. You just show up at the courthouse and then wait for days, or what?
The way it works in Washington is you're scheduled for trial. If your pre-trial judge, the one who's handled the case up to them, is not available to try your case, you go on this wait list. You then wait until a judge is available.
Are you waiting like hours or days or what?
We waited a week and a half.
So you flew, you had to pack up all your shit and that's a nightmare, because you have experts that you got to coordinate, witnesses, subpoenas out, right?
Right.
And you flew out to Seattle, got a hotel or Airbnb or something?
We had a hotel. We had a war room where all our stuff was. The team was out there. We had all our stuff out there,
And you're just waiting.
you're just waiting.
That's crazy. I've heard about that in California too. It's here we have a generally you go on the day that you're supposed to go.
Right.
Different courts in different counties can be a little bit finicky, but we don't have that. We don't have this like waiting thing.
Right.
So sorry to interrupt. So you flew out there, you got all ready, and
So we're out there, and in the course of a week and a half, waiting for assignment to a trial judge. We get assigned to a judge, and basically that same day or that night, we resolve the case. We settle the case. And the difference in the value of the case in Washington versus in Michigan. In Michigan, unless we could have found an exception to the non-economic damage caps, which I thought we could, but it's very difficult.
very
under the
hard,
law.
very hard.
In Michigan, the case was $2 to $3 million in value for the family. Out there, 3 times that amount. I mean, 10 times.
10 times that amount. Yeah. That's such a travesty and so unfair. People are going to be listening and saying, how can that be the case? Right. But what they don't, so in Michigan, we have caps on damages that the jury doesn't even get to hear about. So, right. They only apply to certain cases, which they apply to a lot of the cases you practice in, unfortunately, Bob.
Lucky me.
Yeah. Medical malpractice has caps because of the doctor's lobby. And this is all special interest stuff. I mean, if we're going to be real with each other.
Right.
Why does somebody who gets hurt by a doctor, why should their suffering be worth less than somebody who gets hit by a truck, for example? It's because there's these special interests that lobbied our legislature, and they pass these unfair laws for people, which I believe. But they have medical malpractice special caps that will, if a jury says it's worth X amount, $10 million, it'll automatically be decreased by the judge to X amount, right?
Right.
And products is another one, and I believe the reason is we had a huge manufacturing product base of Ford, Chrysler, GM, and all these others. So they had their lobby with a lot of money and power and special interest get a special exemption for if you're hurt by a product. And I guess this fit into that, right? Because it was a product that hurt this guy, the lanyard thing.
Right. Had the case stayed in Michigan, we would have been subject to what's called the non-economic damage caps. And
for pain and suffering stuff, right?
Yeah, for
and what's the cap now on a product? Isn't it like $500,000 or something? The low
well, there are 2 levels of caps in the product world and in the medical malpractice world. There are 2 levels. They change every year. The upper cap is a little bit over $1 million right now. The lower cap is around $500,000, and so, depending upon which category you fit into, for example, in a medical malpractice case, if you were to have medical malpractice that caused, say, an instantaneous death, that is a lower cap case.
That's crazy.
That's
crazy. So this works like you would go to trial if you had to go in Wayne County in Michigan. Let's say the jury said, this is horrible, this guy's life, the pain and suffering that he had by being impaled and being there, we're going to give $30 million. The judge would then, after the jury did that, say, okay, oops, overridden, and say you really get a judgment of what, 500 or 900 or a million or whatever.
Yeah, in that situation, in products, a death case is the upper cap, which is different than in medical malpractice. So if that had happened and there had been a $30 million verdict, the judge would have reduced the non-economic part of that to basically $1 million. So that shows the huge difference in litigating a case in Michigan versus, in this case, Washington.
Yeah. Well, and they did that to themselves.
They did that to themselves.
I wonder if that lawyer who advised his client got fired after that. Say, what the hell are you thinking? I had a case I don't know, I talked about it on a previous show, but This technique of the defense attorneys to remove the case is really it really tries to, it's a case killer move, right? So I had a case where this dude bought a bicycle that had been manufactured by an Italian company, and it had been sold in Detroit, and the guy was in Slovakia, which is my home country. Marko is Slovakian, actually.
All right.
And the spring, it had a spring-loaded shock. So, it was a mountain bike, so when you went over rocks, it kind of absorbed. You ever see those little shocks?
Right.
And the shock was designed negligently, and when he went over a rock, a pressurized spring blew out of the shock and blasted him in his eyeball and went into his brain. And the dude's blind and messed up. And we filed it in Wayne County because they had distributed or sold one of the bikes here. But they did the same thing. They said this happened in Slovakia. The bike was designed in Italy. And the judge in Wayne County said, nope, we're going to dismiss the case. And then, of all things, they argued that we could just go and file the case in Slovakia. So believe it or not, I started contacting all these lawyers in Slovakia for this guy. And they're like, no way. We don't have personal injury over here. The dude's toast. So the guy went to 4 different lawyers in Slovakia, and we tried to help him. But it killed our case. We didn't have a venue to go to in America, which was a bummer.
Well, and that has happened in other situations as well. I had a case against Daimler Chrysler. The vehicle was designed in Wayne County. It was manufactured in Wayne County, specifically to be sold in the European market. So after it was manufactured, they sent it to Europe. It was purchased by my client's family. And
where was your client?
In Croatia.
Croatia.
And because of a defect in that vehicle, she ended up dying.
What happened?
This was a transmission case where the transmission appears to be in park, but it really isn't in park.
Oh yeah, they had a lot of this Chrysler problems with the Jeeps.
Right.
Yeah.
Right. And this was a Jeep Cherokee.
Yeah.
And what had happened is she was in the back seat of the car with her newly born daughter and her mother. Her husband was in the right front seat, and his son, an adult son, was driving. They were driving in the mountain area of Croatia. The son asked his dad to take over because of the nature of the road. He put it in park, thought it was in park,
right?
And the husband and the son get out to switch sides. As they get out, the vehicle starts rolling, and it rolls off the edge of this roadway cliff.
Oh my God.
Her door opens, she falls out, and is crushed by the car. And
oh my God.
So I filed that in Wayne County, and
where the car was designed.
Where the car was designed, where the car was built, manufactured.
Right.
And the Wayne County judge dismissed the case on what was called a forum nonconvenience. And we went to the Court of Appeals. The Court of Appeals reversed that, and then Daimler Chrysler took it to the Michigan Supreme Court, who, going back to what you said about protecting our industry, said, no, this case really should be litigated in Croatia.
Which is impossible, right?
Which you have the same kind of situation that you had in the bicycle case, plus the damages were minimal as far as what they could recover. And my client, my deceased client, was Croatia's most famous movie actress.
No way.
So, yes. And unfortunately, that case didn't end up in any kind of recovery for the family. And actually,
justice denied.
Yeah.
And that was a clear defect. I mean, everybody knew. Remember, that guy in Hollywood got crushed by the Jeep Grand Cherokee. Right. I had a Jeep Grand Cherokee with that, and you didn't know it was in. I would many times think it was in park, and nobody got hurt, but it wasn't. I'd get out, you'd get gas or something, and then the car would start rolling. It was crazy.
Well, actually, my accident reconstruction expert and I flew to Croatia because that's where the vehicle was, and we tested it, and we were able to duplicate exactly what happened there.
I hope you got a good vacation out of this tragedy.
Well, I will say that it was the one pleasant aspect of this. This was shortly after the war, and obviously Croatia and the other countries over there were developing. But Croatia, even back then, it was a beautiful country. I had a wonderful experience, the case issues aside.
What year was this?
This had to be in the early 2000s.
Yeah, so our Supreme Court in the early 2000s was not exactly friendly to injured people.
Not
and that's
exactly
the understatement
friendly.
of this century. And that's a shame. That's a horrible denial of justice. My guy's in Slovakia right now, blind for the rest of his life because a bike was, look, you're not supposed to ride a dirt bike and have it turn into like a gun in your eyeball.
Right.
It's crazy. And this dude's going to get no justice. And then the defense attorney's like, oh, he can just sue in Slovakia. And I showed the judge, I had like letters from these Slovakian. We had to we had to get them like we had like this, it was written in Slovakian and then we had to pay to get it translated. But that is some bad law on that. And, I was in Argentina for vacation over New Year's, and I had a very interesting conversation. We had dinner with an Argentinian lawyer who has spent his whole life practicing law, and we were talking about the difference between our justice systems. And I said, well, do you have like tort law in Argentina? Like if I walk across the street and I get, hit by a bus or something. And he's like, yes, but like most of Europe, a judge decides. You don't get a jury of your peers. A judge decides your case. And I said, well, okay, let's say somebody's walking across the street and they get killed by a bus. How much money would their family get? $40,000 for somebody's life.
Well, and surprisingly, and that was similar in the Croatian case as well, but even in the U.S. over the decades, the values has changed. This recent case with a lanyard showed the difference between Michigan and Washington. But a long time ago, I had a matter that involved the death of 3 ski patrol men out in Colorado. They were all single, had no children, no dependents, and at that time, a wrongful death, the most damages I would have been able to get for each of them was, as I recall, $70,000.
$70,000,
right?
Even for a dead human being.
Yeah, and even though they had an extended family, parents and siblings, but because they were single and had no children, it was $70,000.
How did they die?
They were part of the ski patrol that was setting off dynamite charges to get rid of avalanche danger. And one of the charges didn't work the way it should, and it went off prematurely before they were in the right position, out of the danger, because what they're doing in that situation is actually causing an avalanche. This is before everybody makes it to the slopes to go skiing. But because the charge went off prematurely, they had not made it out, to a clear zone.
So they had to race against the avalanche and overcome?
Right.
That's horrible.
Yeah.
That's crazy. Well, our Supreme Court, did you read this opinion that a dead baby is now, if you kill a baby, whether through you run it over with your car, the doctor kills it, whatever, that the family can't recover for that person's like future work? Did you hear about this?
I read it.
It's crazy.
Yeah.
That means that it's almost like a defendant's better off if they just straight up kill a human being than if they maim that human being and they require, care and whatnot for the rest of their life.
Yeah. It's those kind of restrictions on what is recoverable favor almost always, if not always, favor the defendants.
Yeah.
And even the damage caps that are in Michigan right now are so unfair. I cite this to clients at times. You can, if you have a 22-year-old father of two, married, who dies an instantaneous death in a medical malpractice issue, the most that family is going to get for the loss is around $500,000, and so that family's going to suffer a loss for 50, 60 years.
Right.
And not that money makes it any easier, but having an exposure, a defendant having exposure, drives things being done correctly. And I can give a whole litany of lists in the automotive world, because I do a lot of automotive product cases, of devices that we now have that were driven because the automotive companies were held responsible in a jury case. You look at your door handles. You very rarely will you see a door handle on a new vehicle now where you push the button in.
I remember the push buttons.
Yeah, and the reason for that is vehicles were rolling over and the button was getting pushed and the person was getting ejected. Rear lift gates on certain vehicles used to have only a single latch as opposed to the double latch on the hoods, where with the hoods, probably anybody who's ever closed the hood knows you have two latches. So if the first latch fails, the other one, the roof won't go flying back.
Yeah.
The rear lift gates of a number of vehicles only had a single latch. So they get in an accident, the rear lift gate goes open and out the rear door goes the person. They now have double latching, backup latch. So as much as the industry and the defendants will say, jury verdicts should be, you have to put a lid on them. The fact is, if they do not have high exposure, it will inhibit them doing the right design or the right treatment or whatever.
Yeah, because it's a cost analysis, right? For them. Remember, like the
Pinto
Ford Pinto?
case.
Yeah.
Right.
I mean, Ford said, well, it's going to cost, we know that this is going to kill people and they're going to get burned up.
Right.
But it's going to cost us this much in lawsuits. And if we actually recall the Ford Pinto and fix this problem that's going to kill all these people, it will cost us more money. So we might as well let the people burn up and we'll just deal with paying settlements. I mean, It's crazy.
Yep.
It's kind of sick. It's kind of evil.
Well, it is sick. I mean, you've got a bunch of executives sitting around conference table making those kind of decisions.
Yeah, absolutely. So tell me about some other crazy cases that you've had. You had the ski patrol. I'm sure you probably had a lot of other products cases that were crazy, or any trials that you did.
There, a lot of the cases that I've had in the product world have been centered around vehicle matters. There was a case we settled a few years ago where, unfortunately, the young man, newly married, basically suffered an internal dislocation of his head because a dealership had repaired what's called a clock spring. It's in the steering wheel that sort of connects everything, the radio, the airbag. It's the kind of electric brain of the vehicle. And the dealership had replaced it. They replaced it incorrectly, so his airbag didn't go off. And
so he didn't know.
He didn't know.
And it was like just this hidden danger there.
Right. And so, that was a hard-fought case because the dealership and the manufacturer were fighting with each other, and there was a huge defense that was put up on it. So that was interesting, obviously. And, most of, usually in the medical and the product area, they are interesting cases because
Yeah.
they have so many components to them. Usually in the product cases, especially with vehicles, you need 4 or 5 different experts to cover
They're
all the areas.
complicated, and they
are.
cost a lot of money. It is if you're going to sue Ford, they're not just going to say, "Oh, we're sorry. Here's a lot of money." I mean, you got to be ready, and you have to spend a lot of money to get experts, right?
Right. Usually in a product, a vehicle product case, you need an accident reconstruction expert. You need a biomedical expert, who is the person who will look at what happened in the accident, what the person who got
Right.
injured or killed was doing. You'll need a defect expert, so whether it's an airbag or a seatbelt or whatever, you need that. You may need a medical person that talks about the actual injuries that were suffered by the person. And then, of course, you have damage experts at times. Sometimes you need a forensic accountant and those kind of things.
Yeah.
And
That's a lot of money. I mean, how much you spend to get all those on in a case, or that lanyard case? How much did you guys?
on the lanyard case, we spent a little over $250,000.
That's a lot of money, and that's your money.
It's our money, right?
That's tied up. I had. Did I ever tell you about my first products case against Ford Motor Company?
I don't think so.
I had no idea what I was doing. I was a few years out. We had a case, and like you said, another lawyer by the name of Eric Berkeley, great lawyer. He's kind of retired now, but he had an auto accident case with. Remember when those cars had automatic seatbelts? Ford would make those cars. For the younger viewers, aren't going to know what we're talking about, but it used to be you'd get in.
The one with on the door.
Yeah, the door had like a little railroad track on it where the seatbelt was in, and you'd get in, and it would automatically go over you. It would go da 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 on the track, and automatically go over your shoulder. The problem was, as the car aged, there was a little motor, like, there's a motor to put your window up and down, and that can burn out after enough uses. The motor on the track for these seatbelts would wear out and not have as much power over time. Now, the problem with that is it's on just a flimsy track, and only at the end of the track does it lock in. At the end of the track, there was like a bolt or a pillar that when the seatbelt got pushed all the way to the end, it had like a hook that locked in to the pillar. So if you were in an accident, it's not going anywhere, right? Because the seatbelt's no good if the seatbelt breaks loose.
Right.
So this dude had this old car, and the seatbelt motor didn't lock in. So he gets in an accident. As I remember the guy's name was Booker Sawyer, because this is like one of those cases where like you never forget. So he ended up flying forward, and his head hit the windshield, and it did a spider web impact on the windshield. So this guy brings me the case and says, "Do you want to sue Ford? This shouldn't have popped out, right?" So I said, "Sure." So I file suit. I have no idea what I'm doing. All right, and I go to my boss at the time. This was at the time I was working at a small firm in Royal Oak, and my boss was a buffoon. And he said, "Well, just sue him." I said, "Well, people are telling me I got to hire all these experts, like you just said." Right. And he goes, "How much is it going to cost?" I said, "It's going to cost a lot of money. The accident reconstruction alone, I think, was like $20,000 just to do a thing." And he said, "Well, I'm not going to pay for that. You don't need that. Just go and they'll pay. They'll pay." It was a disaster, right? And so, they hire very big firms, and I left before the case was resolved. I later found out it resolved for I think it was confidential, but it was embarrassingly confidential. If it was Ford, they should have said, we do not want this to be confidential, because it was so low. Right. But that taught me a lesson that you have to pay a lot of money. You have to be ready, and you have to know what you're doing on a case like that. You can't smudge it like my employer at the time told me to do. He said, "Oh, they'll just pay." No, they won't. And there's all kind of, So
Yeah, I mean, the sophisticated defendants, they know who is ready and who isn't ready.
Yeah.
And I tell clients all the time that we have to prepare this case to go to trial.
Yes.
Because if you don't, I guarantee you it will go to trial.
That's right.
and then you will be on the receiving end of an unhappy verdict. And so, unfortunately, you do have to spend that money. And the other aspect is, I know sometimes people complain about lawyers and their contingent fee contracts. What they forget is probably for every 15 to 20 clients that come to me on complicated matters, I may only file one or two of those cases.
Right.
But in order to determine whether we have a case that is viable that we can pursue, we have to do investigations, hire experts, have matters looked at, and that money is never reimbursed because the clients...
You lose it.
Yeah.
You lose it. Yeah. I
yeah.
mean, just to even get to the point, like going back, let's use that case, that Booker Store case. Had I known what I know now, and had I had a better, I don't want to blame my boss. But he was an idiot. He should have told me, given his experience level, look, here's what we're going to do. Before we're going to sue Ford, and open up Pandora's box, let's have an expert look at the vehicle. Let's make sure that we have a viable case, a strong case, because you will not file a non-viable case because you're going to waste all your money. Would you go to the casino and bet on a game where you're going to lose?
Right.
So, and in that case, we didn't have the experts even once we filed the case, and it was a loss for the firm because of not doing your homework up front before the case. But it takes a lot of work and a lot of money, Bob, like you said. In that case, for example, like we found out that the guy had a lap belt, and even with the automatic seatbelt, you had to still buckle your lap belt.
Right.
Well, he didn't buckle his lap belt, and
But to interrupt you, I apologize.
Yeah, no,
but
go ahead.
In those cases, it was very common, and the manufacturers knew that there was a high percentage of people who were not matching their lap belt. And because once that came across your chest,
you just said, I'm good.
I'm good.
Yeah, most people did. I did when I was in high school. One of my friends had one. He had a Ford Probe that had the thing on it, and we thought it was really cool. I mean, luckily we weren't in any accidents, thank God. But
well, the other two aspects of that kind of design was the fact that, as we talked about before with the door opening, if the door opened like in a rollover, you lose that shoulder belt. The other situation, the geometry on that was terrible. Seat belts should fit in a certain way, going over your shoulder in the right way, fitting on your hips in the right way, and that's the geometry. And if that is not proper, you will not get the full protection of a seat belt. Forget the airbag for a second. But I tried a case against Ford, and the main issue on that was geometry. And
did you go to trial on it?
Went to trial on it, and I lucked out. I took a chance on something, and I lucked out. My client, unfortunately, was deceased. She was a female, certain height, certain weight. The Ford representative that they brought in to be present for that trial, as I looked at him, he was basically the same height and same weight as my deceased client.
No way.
So there was what's called a buck in the courtroom, and a buck is kind of a cutout section of the vehicle, so it would have the passenger compartment and the seat belt. And so I said, I'm going to take a chance. And
it's always dangerous when you do demonstrations and you don't know the exact result.
Right.
The case in point is O.J. Simpson. Remember when
put the
Johnny
glove
Cochran
on.
said, the glove does not fit, you must have quit. What people forget is OJ's team didn't tell him to put on the glove. It was the prosecutors
It was.
who said, we're going to have him put on the glove and show the jury, and it lost him the case.
Yeah.
But anyway, sorry to interrupt you. So
No, so when he was on the witness stand as a designated Ford rep.
in front of the jury?
In front of the jury.
And you have this car half in there?
Yeah, we have the car buck in the courtroom. And so I say, would you step down from the witness stand and sit in the seat? And he came down, sat in. I said, now fasten the seatbelt, if you will. And when he did that, the distance between his chest and the seatbelt was, as I recall, about 10 inches. So
that's not good. It wants to be snug,
terrible.
right?
It's supposed to be snug. And so I said to him, so in a forward frontal collision, which was what we were dealing with, my client would have traveled 10 inches forward before she picked up the benefits of the seatbelt. And he says, yes. And,
was the defense attorney going crazy?
I talked to them later, and yeah, they were, but it's one of those things as trial lawyers that, you have to learn how, I call it, you have to learn to bleed in your shoes. And people say, well, what does that mean? That means that when you have been mortally wounded by something that's happened in trial, all the blood has to drip down your leg and go in your shoes so the jury never sees that you've been mortally injured.
Right.
But it was one of those aha moments, one of the things that I will remember for the rest of my career, because it was just, I'm going to take a chance, and it worked out. But
what did the jury do when they saw that?
You could tell they went, yeah,
Now, what would you have done if the thing snugly fit on him?
I probably would have gone back that night and said, "Oh, you're a dummy,"
with some blood in your shoes.
With some blood in my shoes.
Yeah,
Right,
yeah. But you have to take risks.
Yeah.
Tell me you won that case.
Unfortunately, I lost that case.
Oh my God!
And here's why we lost the case.
Where was the case?
It was in Lansing, in Ingham County Circuit Court.
It's very hard to sue manufacturers, auto manufacturers in Michigan.
Right.
It really is.
Well, and I went back and talked to the jury afterwards, along with the defense counsel, and I said, you saw that it didn't fit. You saw, and her death was caused by a head injury because she got so far forward. And I said, how did you end up with the verdict you did? And they said, well, nothing broke in the vehicle. And I said, well, don't you remember the jury instruction that, something didn't have to break? This wasn't a manufacturing defect case. This was
design defect.
Design case. But the jury totally missed that concept. And so I guess the lesson I learned from that, because, again, they call it the practice of law, because we keep practicing, and hopefully at some point before we quit, we get it right.
Yeah.
But, so it taught me a lesson on you've got to give it certain aspects, make sure you're giving it to the jury in the most simplest terms possible, which I knew before, but I'm just since then emphasized more than ever before.
Yeah, for sure. And that can be particularly challenging when you have extremely complex subject matter like medical malpractice or product liability, right? I mean, and the more confusion there is, the more complications there are, I think it always works against the plaintiff. Because if you're confused, and if the jury's confused or doesn't understand it or whatever, then, well, the plaintiff didn't prove the case, right? I mean, that's generally what's going to happen.
Yep.
Discovering the story is always the challenge in, I think, every case, right? To try to discover what is the story here and why should I care if you're a juror,
Yep.
Why should I care? But I agree with you. You have to take complex things and make them into a story that people care about and that is understandable, you don't want to be overcomplicate the case.
Right. And sometimes, as you know, you have to be more technical, but then if you got your expert on the stand and they're being technical, you then need to draw it down to common sense, common examples, so that you have the evidence in. So you've put in the evidence that you're required to put in, but now you're bringing it down. So the jury, who almost always will not have any education or expertise in the area of the trial, will understand what's going on.
Yeah, for sure. And you have to learn a little bit about it. But that's the great thing that, I mean, you now know. I always say one of the most fun things is I'm learning like a new topic area like every day.
Right. Yeah.
You know, with crazy type things that, you know, you just learn these new crazy areas. And it's always like these small things too.
Well, I say nobody has asked me to scrub in for surgery, but when I'm just looking at an issue, I know what should be done or not done, based upon being educated by an expert. Again, they're not going to ask me to scrub in to help them do the surgery, but you do. You learn a lot of topics. You end up with a broad, perhaps superficial for the moment, education.
Yeah.
But it is interesting.
It is. It's always a lot of fun. Well, Bob, thanks for coming on the show. It was a pleasure to have you. You're a fearless advocate. And so if anybody out there has products or medical malpractice or really tough cases where you need a fearless guy who's willing to spend hundreds of thousands of dollars of his own money taking on crazy causes, you are the man.
Thank you.
You are the man. All right, everybody. Thanks for listening to another episode of Cases Gone Wild, or watching if you're watching us on YouTube. I want to give a special thanks to Bob Tyler. He's truly a good friend and truly a fearless lawyer. We need more lawyers like Bob in the profession, and we'll all be better off for it. If you like the show, make sure to give us a thumbs up, 5 stars, whatever they do nowadays. You can follow us on Instagram. It's Jon Marko or Marko Law, or go to our website, www.markolaw.com, M-A-R-K-O law.com, or 833 Marko Law. We'll get you hooked up with Bob Tyler, whatever else you need. Remember, we're throwing, if you're a personal injury or plaintiff's lawyer or civil lawyer on the good guy side out there, we are having a conference on June 20th and 21st in downtown Detroit. It's the Michigan Trial Lawyers Summit. Go to mtlsummit.com and register now. We'll see you in another 2 weeks for another episode of Cases Gone Wild.